On Tuesday, the Supreme Court of India came down heavily on the misuse of NRI quotas for admissions to undergraduate medical courses in the state of Punjab, calling the spate of widening NRI quotas a fraud. A bench of Chief Justice of India D.Y. Chandrachud, along with Justices J.B. Pardiwala and Manoj Mishra, likened the broadening of these quotas in government-run colleges to a money-spinning machine. These remarks were made when the court was hearing a petition challenging the Punjab and Haryana High Court's September 10th decision, where the court had refused to quash a particular clause in a prospectus issued by the Chandigarh administration for admission to undergraduate MBBS courses. As per this clause, relatives of NRIs were excluded from admission to MBBS courses. While these were only observations, meaning that they were not binding in nature or even penned down in the order, they certainly hold some persuasive value. What happened in the Supreme Court? The three-judge bench of the top court upheld the Punjab and Haryana High Court September 10th ruling, where the court had dismissed a petition challenging the narrowing of the definition of foreign Indian students under a prospectus issued by the Chandigarh administration for undergraduate MBBS courses. As per a certain clause in the prospectus, relatives of non-resident Indians or NRIs were excluded from the definition and scope of the foreign Indian students. Dismissing the challenge to the High Court's two-judge bench order, the bench led by Chief Justice of India D.Y. Chandrachud said, "We see no reason to entertain the petition under Article 32 of the Constitution." Notably, this is not the first time that the Supreme Court has criticized the misuse of NRI quotas. In the 2005 case P.A. Inamdar and others versus State of Maharashtra, the court had said that NRI seats should be used by genuine NRIs only and that merit cannot be done away with. During the proceedings, the bench also remarked yesterday that there could be a possibility of distant relatives settled abroad getting admissions ahead of meritorious candidates. Look at the deleterious consequences. The candidates who have 3 times higher marks will lose admission, the court said. Adding that it will put a stop to this business, the court said that the Punjab and Haryana High Court was absolutely right in its decision. What was the case before the High Court? In Sridham Anand versus Chandigarh administration, an aspirant was seeking admission to the MBBS 2024 course in the Government Medical College and Hospital, also known as GMCH. In his petition, Anand challenged Clause A6 of the prospectus issued by the Chandigarh administration for admission to MBBS courses, where the definition and scope of foreign Indian students was restricted to exclude the relations of NRIs. The plea argued that although both MBBS and BDS courses were being run by the Chandigarh administration, the wards of NRIs were eligible to be admitted to the BDS course but were excluded from the MBBS course. The petitioner also argued that the Chandigarh administration had no power to exclude NRI wards from the definition of foreign Indian students due to entry 66 of List 1 of the 7th schedule of the Constitution, which basically deals with the coordination and determination of standards in institutes for higher education or research and scientific and technical institutions. On the other hand, the state government said that for admission to BDS courses, the 15% quota for foreign Indian students or NRIs was prescribed according to the norms followed by the Punjab University, and that it was a policy decision to restrict the admission scope of students to MBBS courses. It also said that since the decision fell into the realm of policy, the scope of judicial review was limited. What did the High Court rule? On September 10th, a bench comprising Chief Justice of the Punjab and Haryana High Court, Sheel Nagu, along with Justice Anil Shetarpal, said that although a common prospectus was issued by the Chandigarh administration for admission to the 3 colleges, all 3 were separate and distinct, adding that time and again courts have adversely commented on admissions to the NRI category. The bench pointed out that for admission to MBBS courses, a policy decision was taken by the Chandigarh administration, which was to restrict the entry of candidates while simultaneously laying down a narrow eligibility criteria for the foreign Indian students. In its 23-page ruling, the two-judge bench reasoned that the government's decision to exclude the blood relations of the NRIs was to allow entry of those foreign Indian students who have genuinely been residing in a country besides India. Underlining that this was a conscious decision taken by the Chandigarh administration, which fell into the realm of policy, the court said that the scope of interference or judicial review in such cases was extremely limited. The court also said that the petitioner failed to draw its attention to the violation of any provision of the Constitution or any statute. Finally, the bench said that it did not find the distinction between foreign Indian students and NRI students for MBBS and BDS courses to be discriminatory, as both colleges were separate and taught distinct courses. Refusing to quash Clause A6 of the prospectus issued by the Chandigarh UT, the court said that the centre's power to give directions to the state government shall be confined to the scope of entry number 66 of List 1. The court also said that although entry number 25 of List 3 does enable the state government to make laws for education, including technical education, medical education, and the universities, these are subject to provisions of entry number 63, 64, 65, and 66 of List 1, the court said. The court also cited the Supreme Court's ruling in PA Inamdar versus State of Maharashtra, where the court had observed that more often than not, the admission under the NRI category is a misnomer, and reservation under this category is amenable to abuse by less meritorious students who can afford to pay a huge fee. What was the Inamdar case? On August 12, 2005, a 7-judge bench of the Apex Court led by then Chief Justice of India R.C. Lahoti held that limited reservation of seats in unaided professional colleges not exceeding 15% may be available to NRI dependents on the discretion of the management. However, this would be subject to two conditions. First, that such seats should be utilized in a bona fide manner by NRIs only and for their children or wards. Secondly, within this quota, merit should not be given a complete go-by. Besides this, the court also noted that it's common knowledge that some of the institutions grant admissions to a certain number of students under such quotas by charging a higher amount of fee. The court added that usually neither the students who get admissions under this category nor their parents are NRIs. In effect and reality, under this category, less meritorious students who can afford to bring more money get admission, the court said. That's it for today. For more such updates, keep watching The Print. This is Khadija Khan from New Delhi.